Welcome to Your Strata Property, the podcast for property owners looking for reliable, accurate, and bite-sized information from an experienced and authoritative source.
Hello and welcome. I'm Amanda Farmer and I have with me today Reena Van Aalst from Strata Central. Hey Reena.
Hi Amanda, how are you?
I am great and you must be feeling fabulous after your time overseas. How was your trip?
Oh, it was fantastic, Amanda. I had a really nice time. It was so good to be away and now I am back into the thick of things.
I'm sure you had a long list waiting for you when you got back, and I know you're going to share a little bit about the conference that you attended over in Spain. So I'm looking forward to hearing all about that. Before we get there, jump in and give me just one of your challenges this week, Reena.
Well, this is an interesting challenge, Amanda. It relates to a reduction in office bearers cover. So I don't know if any of our listeners, either managers or owners corporations, have had this happen, but in one particular scheme that we've had an owner that has submitted many applications at the Tribunal at NCAT and there's only one, actually, I think one in the whole time. But anyway, so therefore the brokers said we're going to reduce the office bearers policy actually to zero. And I'm thinking, well, why? I mean, the committee hasn't done anything wrong. Anyway, so we managed to get like a couple of $100,000 in cover after a bit of argy-bargy. But then what happened was the matter went to the Tribunal and the Owners Corporation won the matter. And then when that happened, the insurance broker didn't actually come back to us and say, well, we're going to reinstate the policy in terms of office bearers cover back to what it was prior to the reduction. So I emailed the broker and I said to the broker, what's going on? Why is this happening? And she said to me, oh, well, the insurance companies, they're so overstretched and overwhelmed with work that they don't even check anything. So they're just basically looking at things on a desktop basis. And I thought to myself, well, we're paying all these premiums. We have paid premiums in the past. And in this case, the broker was the one that actually had not done their job by advising the insurance company that the Owners Corporation had won the case, that there were no findings against them, and therefore that the office bearers policy should be reinstated. And at the time, Amanda, what happened when the first advice came to us about not having any office bearers policy, the committee wanted to resign. And in a sense, we can't manage a building without a strata committee. We only have partial delegation for just about everything that we do. And so we actually sought advice from you, Amanda, and you did state that there are provisions in the legislation that protect a strata committee if they are acting in good faith. And therefore, the fact that they didn't have the full level of cover of the office bearers policy was in fact okay for them to remain on the strata committee because they actually all wanted to resign. So it was quite a bit of a scare for us. So I think that sometimes the impact of these decisions that are made by insurance companies are not made with proper consideration. I was told by the broker that when I was trying to understand why we had this cover removed, and they said, oh, well, they don't really look at all the details. They don't look at the fact that, even their own expert, which they had appointed on our behalf to represent the Owners Corporation at the hearing, the engineer, there was a conclave that was appointed and there were 3 engineers that were consulting together. So they knew from the expert's report that they had appointed that we hadn't done anything wrong. The Owners Corporation hadn't neither had the strata committee. The second thing that was they had a lawyer appointed to defend the claim. So the lawyer could see from all the evidence that we provided that the committee had acted properly and in good faith and attended to all the issues and repairs that were requested. It was more about the owner not being happy with the methodology. But even though those things were happening, the other part of the insurance company doesn't even register any of this. So doesn't know what the right hand's doing. And so I think it's one of those things where I think for any owners corporation, the biggest portion of their expenditure is insurance premiums. Yet because of the state of the insurance industry at the moment, we're having to, as managers, follow up the broker follows up the insurance company. And, again, that's more time for us and more fees for the client.
And I wonder how many strata managers do actually follow up something like that. So, Reena, you were attuned to the fact that, okay, we've been successful in this case. There is now no question, or there can be no real question about the strata committee's actions. They've essentially been exonerated by the tribunal. So I'm now going to go back and see if their insurance cover can be upped. I'm not sure that a lot of managers would have that on their list to do.
Yeah, exactly, Amanda. Yeah, but You're right. I mean, obviously, I'm always trying to make sure we look after our clients, but it's one of those things where, again, you've got to be always thinking ahead of people. And again, I think this is a very timely subject at the moment with insurance commissions and remuneration and brokers, etc. And the thing is, everyone knows that insurance policies are going up so significantly for many schemes, and especially for this one, because again, the more claims you have, the more they increase your premium. So, and this is probably, as I said just before, the highest part of any budget for any expenditure for a building is their insurance premium. So you're paying a lot of money, but then you've got to do the chasing. So
frustrating
when you weren't happy at all. So something just to think about in terms of any buildings where they're now, perhaps the insurers are becoming more harsh in their assessment of office bearers' policy and cover.
And perhaps even extending that to building insurance policies where there might be some kind of notation on the policy, perhaps a higher excess because there are certain items that haven't been rectified, and it may not be top of the list for a committee or a strata manager. Once you do attend to those items, make sure you go back to the broker or directly to the insurer and let them know that you've done these things and see if those notations can be removed or however it works in the insurance world, so that if you do have a claim, then you're not restricted when you shouldn't be.
Yeah, exactly, man. That's right. And sometimes you don't realise it until it happens that, oh my God. Yeah. So that's
and guess who's going to get blamed for that?
Exactly.
Strata manager.
Yeah.
Thank you very much for sharing that challenge, Reena. My challenge today comes from our member forum. Sometimes there's some questions that crop up in that forum and I say, oh, that's a great one for me to bring to Reena to solve. And this one is a real brain bender. Reena, we have spoken about this on the podcast before. Your recommendation, which I think is a good one, that when buildings are striking their quarterly levies at their AGM, they should also have a motion that makes clear that the levies will continue at the same rate until redetermined. And that just makes sure that if you're a little bit delayed in having your AGM the next year, the strata manager can still issue levy notices for the next quarter. You are going to be able to keep the money coming in even though you may not have officially struck the levies for the next year. And I see a lot of agendas with that very standard now motion on there that levies will continue at the same rate until redetermined. A member in our forum asked this question: Amanda, if we are, under the New South Wales legislation, supposed to be setting levies in accordance with the budget, which we have determined first, so the order at the AGM, first of all, we determine the budget, then we set the levies, how can we have a motion that keeps the levies rolling on if we don't have a budget that keeps rolling on when the legislation tells us we are supposed to set levies in accordance with the budget? Is it legal to set levies in the absence of a budget for that same period? And I went, oh, that's a good one. Very clever. And apparently it was that person's strata manager, perhaps in consultation with a lawyer, who had picked this up and said, if we're going to have a rolling levy motion, which is often what they're referred to as, we need to have a rolling budget motion as well, and essentially make clear that we are extending the budget in the same amounts proportionately for perhaps another quarter if we are going to extend the levies in the same amounts for another quarter. And I had a look at the relevant sections in our legislation. I had a look at Section 79, which is our budget section, and Section 81, which says that we then raise levies in accordance with the budget that has been determined. And I couldn't really see a way around that one. I don't know if this has come to your attention before, Reena. It was the first time I had heard it.
No, it actually hasn't come to my attention, Amanda. But if I look at the legislation, it says an owners corporation must at each AGM estimate how much. So I don't know how you can estimate before you even have an AGM by continuing the levies at a certain rate. That's number one. And it says here, when estimating the amount that needs to be credited to the admin fund, or the cap must have before it a statement of the existing financial situation of the strata scheme and estimate of receipts and payments. So the thing is that you obviously got to take into account what money you have. I mean, obviously you're the lawyer and I'm not, so I don't really know if it's saying that you must have a budget in order to be able to credit money to the admin or capital, because you can strike a special levy at any time anyway. So that doesn't require you to have a budget. That just requires you to say that there's a shortfall in your funds to do budgeted work. So, and that also flies in the face of the fact that now an AGM can be held within 12 months of the financial year. So on one hand, no one's saying that you have to have it even earlier, which would sort of predicate the argument that you had to have a budget. In terms of cash flow, I think that motion has been included to allow the owners corporation to continue to be able to fund its expenditure until the revised budget is passed, or the budget is then passed at the AGM, at which you look at how much money you've got in the bank because you've already collected that 1 quarter or 2 quarters. So, yeah, I mean, obviously I haven't looked at the legislation in the way that that person has said that, and it says that you must, when you're looking at your budget, you look at your levies, but the levies will show you that you've already had some money coming in the first quarter, and therefore you are looking at the funds. So I'm not really sure if you can say that without a budget you can't have levies. It just says that you need to look at your financial situation when you've passed your budget. So I think it's not as, I'm not sure if it's where it says that you can't do that. It says when you estimate amounts that need to be credited, you need to take into account how much you've got. But so how much you've got would include the first quarter. So if you're raising, say, $500,000, you've already raised 100. You only got to then raise 400,000 for the rest of that year.
Yeah, I think the point was that in having this motion to continue levies at the same rate, you are essentially striking more levies, but you haven't got a budget to back up those additional levies because your budget only goes for 12 months and you're striking levies for perhaps 12 months plus another quarter.
Yeah, but those expenses aren't stopping just because they haven't been budgeted. So that's a very sort of, and also, I mean, sometimes what we're doing now, we're actually budgeting higher. So what we're doing now, we're actually budgeting the first quarter of the new year is going to be higher because we know the levies, the budget's going to be higher. So we're already crediting a higher amount than just keeping it the same, because otherwise any increase will have to be borne in either 3 quarters or 2 quarters. So, and sometimes it's a cash flow thing. Sometimes we know that we have a bill coming. Let's say it's your insurance premium that's due on the last day of, say, your financial year. Then you got to make sure you got the money in the bank so that the first quarter could be even higher. So again, it's not as sort of, yeah.
The other thing that I noticed in looking at these sections, unless I'm missing it, there doesn't seem to be any legal requirement that your budget cover 12 months.
No, that's right.
You can have a budget for 18 months if you want. You can have a budget for 9 months if you want. I don't know if buildings ever do that, but it's certainly not in there that it needs to be a 12-month budget.
No, it just says at each annual general meeting, but you're right.
To meet the estimated expenses. It doesn't say the estimated expenses for the next 12 months or for the financial year.
No.
That might be somewhere else in the Act where I'm missing it. Someone will let me know if I'm wrong, but, there's an idea that you could approve a budget for a limited period or a longer period than 12 months. But look, as I think I answered this member in the forum, is anybody really complaining about this? Are we creating a problem that we don't have here? I think it's important to think practically and pragmatically about these things, especially when there seem to be gaps in our legislation, and make the least worst decision. And I think leaving your building short of funds because you might be having an AGM later than planned is probably not a great move. And I would be surprised if somebody were critical. Well, maybe I wouldn't be surprised about them being critical, but I'd be surprised if there would be found to be a reasonable basis for someone to be critical of that kind of practice on a pure and technical reading of the legislation. So I'm certainly not here today suggesting everybody stop passing these rolling levy motions. I don't think you're allowed to do it. I just thought it was an interesting brain tickler for us.
Yeah. Or, I mean, the other way that it would be not so good is to say, let's have a special levy on the first, which would meet the shortfall because we haven't got a budget and we don't know what we're going to spend. So the other thing also, Amanda, too, is that if you don't have that first quarter coming in, then you've got to then have it paid very close to the second quarter.
Yes.
Yeah, so it actually means that the way it's being done is it's evening out the payment cycle because people never sort of think, oh, well, I haven't paid levies for 6 months, so it doesn't matter, I'm paying all this now. They think, oh, I don't have the money now because people obviously spent the money or, that sort of thing doesn't psychologically link together. But we're actually increasing the first quarter already so that because we know levy is going to go up. So even if they decide to raise less than the rest of the year, at least we know we've got that first amount coming in, covering costs, and sometimes buildings have money in term deposits. So again, if you have money in term deposit, you can't just go break it because you've got to give a month's notice. And sometimes I've had buildings where they've run out of money because they've had money in term deposits and they didn't raise enough money in their normal thing. So we had to basically rob Peter to pay Paul because they had all this money in term deposits. They spent too much in their normal fund And they go, 1 month's notice to break a term deposit. I said, yeah.
You hinted earlier, Reena, that perhaps part of this problem is due to the requirement now that you only need an AGM once in each financial year, whereas previously you had to have your AGM within 2 months of the anniversary of the last one. It's my recollection of the old legislation.
Oh, no, of the first AGM.
So then, assuming that had been complied with year on year, you would always be holding the AGM at around about the same time, give or take 2 months.
Yes.
Do you think that was a better process? Do you think that helped buildings focus that AGM date a little better?
Not really. I think most of us do want to hold our AGMs very quickly after our financial year end because we want to make sure that we set levies at the correct rate. You don't leave it for 6 months and then have to do one, increase it by double and like a 10% increase overall annually. If not done within 6 months, is 20%. You know what I mean? Like 10% annual is 20% payable. So I think none of us want to do that. And no one ever complied before. As in people didn't necessarily comply because they sometimes might have had delays for legal reasons or they're waiting for something to come in. So, and then there were no cases about people not having them on time. So I think no one's delaying them because they want to delay them and because of legislation. I think it's more of the fact we want to get the right amount of money in quickly. It's just that there are sometimes things like other issues that there's no point having an AGM if your building management tender hasn't been done and you don't know if your building management's going to go up or down or...
So it gives you more flexibility, which you think is helpful.
Yeah, I think it has been, yeah. But I think, some have been delayed, but not to the extent that I think anything to do with legislation would, but let's now change the Act to say within 6 months rather than each financial year. I don't think that's the case. But that's only my personal experience, but it could be different for others out there.
Good to know. Well, thank you for having that discussion with me, Reena. Over to your win for this week.
Yeah, well, part of my trip included attending the International Research Forum on Multi-Owned Properties. That was held on the 15th of May to the 17th of May in Tarragona in Spain. And that was put on by Hazel and her team from the University of New South Wales. And we had some great speakers that attended that and gave papers all from all over the world. Michael Tees was one of the ones that was from Australia as well. And I think that showed us, in a sense, all the problems that we're facing here in Australia are very similar in the world as well. So not as if like Australia is unique in that sort of multi-apartment living, all the challenges that we're facing. I think Australia is much more strongly focused on making sure that buildings are well maintained, and we have the capital fund, forecast and buildings having to repair and maintain as a statutory obligation. Other countries don't have that. We had speakers from Australia, we had speakers from the US, from Belgium, from Spain, Israel, all different countries. And in Spain, 70% of people live in apartments. So it's a height. So that was a good place to sort of talk about multi-unit living and all the challenges. And so, yeah, it was fantastic. And I learned a lot in terms of how do people do levy arrears over there, what's the interest rates, all the different things that, and it was more an academic conference. But it was good to listen to academics from different parts of the world and talk about their experiences. We also had someone from Singapore as well. So it was very well. We had, and Ethiopia too, Strata in Ethiopia.
Fascinating.
So there you go. Yeah.
Well, look, you let me know who the stars of the conference were, and I would love to invite them to have a chat on the podcast. That would be great.
Yeah, definitely. Yeah.
Always good to look beyond our own backyard, I think, to see how others are doing it differently, doing it better, to see perhaps that with all of our problems, we're making a good fist of it as best we can compared to others.
But I think the main takeaway for me was that all buildings in countries are ageing and needing more money, and therefore this is a very common theme in terms of what was being spoken about at the conference and about whether buildings have to be, like the strata renewal process should be taking place, how it should take place, and that sort of mechanism was for buildings that needed to be basically demolished. And don't forget that there's some older, like Strata has been around, I think, in a lot of countries for many years in some form of living. So it's one of those things that it was just interesting to understand the termination processes in other countries, and then all of them now are more at 75%, like we have now in New South Wales. So it was interesting. Yeah.
Excellent. Well, thank you for representing us over there. Wrapping up with my win for this week, I wanted to share perhaps a little bit of technical litigation procedure with everybody. I was recently involved in a case that is still ongoing, and I might be able to say a little bit more about it in the future. But as part of this case, it was necessary to transfer the proceedings from the district court where they were commenced over to the tribunal. I'll give you a bit more information. This is a case where a lot owner is being sued by their owners corporation for an alleged failure to pay levies. And fairly straightforward legal proceedings, you would usually think. The amount of unpaid levies was quite high, over $100,000. So the proceedings were commenced in the district court by the owners corporation against this owner. And this owner has taken the position that the levy that is outstanding is invalid and that she is not required to pay it. She was encouraged to seek advice from a Strata lawyer who is better able to understand than perhaps a straight litigation lawyer the nuances involved in that kind of a case. That Strata lawyer ended up being me. And when we had a look at the case, we realized that there was a little bit more going on here than just an unpaid levy. And for that reason, the district court was probably not the appropriate place to decide the dispute. The tribunal has power under our Strata legislation to do certain things like declare that a resolution creating a levy is invalid, or to find that a levy is excessive or otherwise unreasonable, or even the power to appoint a compulsory manager if things are not happening as they should be happening in a Strata scheme. And for that reason, it was our position that these proceedings properly belonged in the tribunal, not the district court. I'm classifying this as a win because when this was explained to the owners corporation and the owners corporation's lawyers, they very promptly agreed that the proceedings should be transferred over to the tribunal. So that is in the process of happening. What seemed to be a fairly straightforward levy recovery proceeding has morphed into something a little bit more complex that involves some other areas of Strata law. And where that happens, it is important that your proceedings are in the right jurisdiction, and there is power in both the district court and in the tribunal to make sure that that transfer can happen.
So, Amanda, do you need the consent of the owners corporation to allow you to transfer it, or could they have fought it and said no?
Yeah, they could have fought it. We didn't need their consent. The way that it's done is that you file a motion in the district court, which is like an application, a request of the court to say we would like to transfer and these are the reasons we'd like to transfer. As it turned out, the owners corporation said, yep, you can file your motion, but we consent to that motion. And generally the way things happen, if there is consent to a motion, then the orders are simply made. And the result, in this case, a transfer, happens quite smoothly. Now, I appreciate I'm being a little bit cagey about the facts in that case. They are interesting. I'm sure I've piqued your interest. I hope I can share a little bit more about that case with you all in the future.
So I can probably just ask you one thing, Amanda, and obviously you can say whether you can answer or not, but I assume it was a quarterly levy, but it wasn't just like a normal, $1,000 a quarter type levy. It wasn't that sort of levy.
It was a special levy.
Okay.
And a special levy raised for, allegedly, a particular purpose.
Yeah.
And it is that single special levy that is being disputed, yes.
Okay.
Yep.
All right. So it's not your regular quarterly levies that...
No.
Yeah. Okay.
No.
Yeah. Okay. That's interesting. Well, I would wait to hear more when you are able to tell us more.
Yes, indeed. Thank you very much for joining me to catch up on the podcast, Reena. We did miss you during your time away and we're glad to have you back. I'll let you back out into your busy schedule and look forward to catching up with you next time.
Thanks, Amanda. Take care. Bye.
Thank you for listening to Your Strata Property, the podcast which consistently delivers to property owners reliable and accurate information about their strata property. You can access all the information below this episode via the show notes at yourstrataproperty.com.au.